Hi and good morning and welcome. I'm Ian Pearl and this is one of OGR Stock Denton's webinars on issues and difficulties relating to the coronavirus at the moment. We've got a panel discussion today with my colleagues, Stephen Silverman, Hayley Trovato and Robert Rosenberg. I can see at the moment the participants are joining fast and furious, and we'll wait for it to click up a little bit more. And while we're waiting, I think discuss with my colleagues, it's an amazing thing at the difficult time we're in. What one of our 90-year-olds has achieved in these difficult circumstances. Stephen, anything to say on that?
If you're talking about Colonel Moore, he's in fact reached 100.
Is it 100?
100, yeah. It was his 100th birthday yesterday, and a fly past by the RAF. I think he's raised 29 million. I'm sure he's going to get it up to 30. I understand that he was closing off his Just Giving page last night, I think. But it's an incredible achievement when someone starts off by hoping to raise £1,000. And look what happened. It just shows the great British nation, and everyone got behind him at these difficult times. And it's a good news story. We need some good news stories at the moment. I think it's great.
Indeed, I think, you know, it just does go to show that always these situations bring out in the majority the best in people, and you also see the flip side as well to a small extent. I think let's focus on the positive.
I think before we start, I think everybody who's attending and Stephen and Robert all just want to wish you a very happy birthday, Ian, for today.
Happy birthday, Ian.
Happy birthday, Ian.
Thank you very much for bringing that up. I'm delighted to be 22. Bit upset that my 21st year has passed. In fact, many years ago. I think now, without further ado, the numbers are sufficient, and we'll begin to start. The idea of today, I'm not sure if you've got if you've attended many of these sort of legal seminars in the past. The idea of today is we're very aware that as lawyers, our own specialisms, we departmentalize and we compartmentalize. And I, by way of example, focus exclusively on litigation and majority on commercial property work and commercial disputes. But we recognize that other professionals and businesses and individuals, their problems are not compartmentalized in that way. And that's why we thought today would be a useful opportunity to bring all our different specialisms together. And in particular, unfortunately, I think it would be fair to say that the situation we're in at the moment has created what can be described as a perfect storm. And because of that, many areas are affected. So I think one of the main issues that when one discusses the business impacts of the coronavirus, the phrase one often hears said all the time is cash is king at the moment. And on that note, without further ado, I'm going to introduce Stephen Silverman, who's my colleague in litigation, and he's going to discuss issues surrounding this. Stephen.
Well, good morning. Thank you very much, Ian. As Ian says, cash is king. We are living in very difficult financial times at the moment. A lot of businesses are struggling financially. And I'd like to give you a few tips this morning as to how you can enforce any outstanding debts and what action you can take to put yourself in the best position to ensure that you monitor your debts and to avoid any future debts that you can't recover. So let's start with some top tips, and then we'll go on to some possible enforcement methods that we can use and advise you on. Firstly, in these times, you really do need to act quickly. Customers may be really pleased with the service that you provided, but they're going to forget that in 4 or 5 months' time. And when it comes to enforcing debts which are 4 or 5 months old, it's a lot harder than trying to enforce them if they're only a couple of weeks old. So don't let debts linger. it's important to start to try to recover those as quickly as possible. Information is going to be very important. You must know who you're dealing with. Are you dealing with an individual? Are you dealing with a partnership or a company? Because the way in which you're going to enforce those debts is going to make it's going to be a big difference as to the entity that you're dealing with. Also, get as much information as you can. Don't be embarrassed to ask information about the people that you're dealing with. You want their full names, because that may be useful for a bankruptcy search later on, or for other financial searches. You also want to get email addresses so that you can communicate with them easily, particularly now where some people aren't monitoring or being able to pick up their post properly. You want to be able to get bank details if you can, because they can be useful when you come to enforce judgments later on. If you've got bank details, I'll mention that later on. So get as much information as you can. Also, make sure that you keep and file properly invoices, so that if there is a problem and the solicitor needs the documents, you've got them to hand, because solicitors are going to need the documents quickly if they're going to try to enforce an outstanding debt. Also, be careful with credit limits. What quite often happens is you get a new customer who may put forward, who may have a couple of, say, 2 or 3 orders, and they pay very promptly, and then all of a sudden they put in a huge order, and that's normally the one where someone can get stung. So if someone in these particular times wants to have a large order put through, then don't necessarily extend the credit terms, or discuss with them how they're going to pay, or perhaps even ask for some security for the debt or something like that. Terms of business. Make sure your terms of business are up to date and correct. For instance, you may want to have a clause in there to ensure that if you supply goods and someone doesn't pay for the goods, you can actually go into their property and recover those goods because titling the goods doesn't pass. That's something we can look at for you. We can look through your terms of business. So now, just going on to some of the ways in which you can enforce debt if unfortunately you found yourself in a position where someone won't pay. Well, as I said, you've got to act promptly. We often find that a solicitor's letter, a 7-day letter demanding payment, will get someone to actually sit up and pay attention who may have up to now just been ignoring the debt. Also, we can then proceed once we've written the letter. If they don't respond, then you may want to issue proceedings. Now, obviously, at the moment, the courts are running at a much slower pace because of social distancing. They can't have so much staff, so there is a delay in issuing proceedings, which is another reason for getting your letter of action out quickly and acting promptly. Because what you want to make sure is that when hopefully we come out of this crisis, the post-coronavirus bottleneck starts to ease, that you're going to be at the top of the queue and your proceeding is going to be issued first, because there's going to be an awful backlog. So you need to act promptly. If you do issue proceedings and you get a judgment, then it's only a piece of paper. It has to be enforced. And there's a number of ways of enforcing that. One of the ways that we do that is by instructing bailiffs. And we can get bailiffs to go round to an individual's premises to try to enforce. We will often register a judgment in the High Court and get a High Court sheriff to go round. And that's always can be quite successful. However, things are changing, and things are changing fast. And in fact, only last week, there were some new regulations which came into place in order to cover social distancing. I'm going to read these out because if you don't mind just looking at the paper, because they're quite long. They're actually called the Taking Control of Goods and Certification of Enforcement Agents, bracket amendment, close bracket, bracket coronavirus, close bracket, regulations 2020. I'll refer to them as the 2020 regulations. That's much easier. What they actually do, they actually prevent enforcement agents such as bailiffs or High Court sheriffs now going round to residential premises because of social distancing. And the High Court, the Ministry of Justice, has actually recognised that social distancing has to be observed. And so bailiffs and High Court sheriffs aren't really now going round at all to residential premises, whereas before they may have been able to seize cars, which are valuable. Now that can't be done. So we have to look at other options. One other option that we can do is to issue a statutory demand. A statutory demand is a document that more or less is telling the debtor that if you don't pay within a certain period of time, then we're going to issue either a bankruptcy petition if you're an individual owing more than £5,000, or if you're a company and the debt's over £750, a winding up petition. However, things aren't quite so straightforward anymore, because the government are looking at proposals to stop people being able to issue statutory demands if the debt has really arisen as a result of the coronavirus and someone finding themselves in a position now where they can't pay the debt because of that. Also, even if you do issue your statutory demand and you then want to proceed with your winding up petition, I'm afraid things aren't going to be easy at all. The winding up court sat on the 25th of March, which was the first time after the lockdown. And on that particular day, there were 50 people and judges there. And there were 306 petitions that were going to be heard that day, winding up petitions. Every one of them was actually put off for 12 to 19 weeks. And those are the ones that were before the court at that time. And not only that, but the government's considering a moratorium on issuing any winding up petitions or bankruptcy petitions if the debt's arisen because of the coronavirus. And the government business secretary, who is the Right Honourable Alok Sharman MP, is going to be looking at this closely, and we're expecting there to be some new regulations coming in. So if we can't proceed with winding up or bankruptcy, then what else can we do? Well, there are various other enforcement methods that you can take. And this is where it becomes important to make sure you've got the information. For instance, you can go for a third-party enforcement order. That means that if your debtor is owed money by somebody else, you can serve an order on that person and get the money directly paid to you. This can also be attachment of earnings. But in order to do this, you really want their bank details so you can move quickly and get those orders and serve them on the bank, serve them on the employers. They can be very good ways of getting money out of people. So those are the major ways of enforcement that I really wanted to speak about. And what we would actually do in any given situation is sit down with a client, look at the picture in the round, and actually decide the best way to enforce the debt for them, and to give advice, as I say, looking at terms of business, etc., as to how they can best place themselves in a position to avoid that in the future. I'm now going to hand back over to Ian.
Thank you, Stephen. That was enlightening, and it just shows all the different ways that one can try and recover. Stephen, I was listening carefully to what you're saying, and I just wonder, in the current environment, if somebody that owes you money contacts you and says, "Look, it's not I don't want to pay you, I just don't have it." Have you got any advice, any guidance in those circumstances?
Yes. Firstly, I'm pleased that you're listening carefully to what I'm saying, Ian. That's always good to hear. And as far as those situations are concerned, it may be that you really want to negotiate with your debtor. They may genuinely not be in a position where they can actually pay you everything at the moment, but you could ask them to start paying by installments, or you could ask for some form of security. Why not take a charge over some property, so that if there is a problem and they go bankrupt, you'll at least be a secure creditor and have something that you can try to attach your debt to.
Thank you, Stephen. As I said before, enlightening. These are very difficult times insofar as credit and recovery of debt. And I'm sure all the accountants that are listening in at the moment are more than live to this issue. Obviously, within business at the moment, one of the most crucial areas that's impacting upon the country as a whole is the employment circumstances. And indeed, a word that was otherwise only known in military circles until a few weeks ago is now the first on the lips of almost everybody in the employment sector, which is furlough. And for this reason, we're joined by Hayley Trovato, this morning, who's a specialist in our employment department, and she is going to be talking to us today about furlough leave issues. So without further ado, over to you, Hayley.
Thank you, Ian. Yeah, furlough, a word that I had never uttered, and now is in my top 10 most used words, I think, every day. So that's what I thought I'd talk a little bit about today, because one of the most significant measures that's been introduced by the government during this pandemic is the Coronavirus Job Retention Scheme, which introduces the concept of furlough. So for those of you who may have not heard of it, I'm not sure there's going to be very many of you. This means, very briefly, that employees, they're put on a period of leave where they're not required to work. And then it provides for employers to recover a proportion of their pay from HMRC, which is 80% of furloughed employees' usual monthly wages, up to £2,500 a month. Plus also the associated employer national insurance contributions and minimum auto-enrolment employment pension contributions. So this has the effect that employees who may otherwise have been made redundant or laid off due to the lack of work because of the coronavirus pandemic, they remain on the payroll, and at the same time it frees up money for businesses to help them with their cash flow. Importantly, furlough does not change the employment relationship between the employer and the employee. That continues and remains unchanged. So at the moment, the scheme is going to last until the end of June. It may very well be extended further by the Chancellor. We don't know, we'll have to wait and see. And it is backdated until the 1st of March. So this is a very new scheme, and it was brought in very, very quickly. And as with all new schemes, there's questions, uncertainty, issues that arise. We've had guidance almost on a daily basis from the Treasury and HMRC. It's been constantly updated, but that is just guidance. There's no statute, there's no case law. So inevitably, there's issues that have arisen and that remain unresolved and that may never be resolved. But I thought I'd just look a couple of these more complex areas where we've had questions about from clients and have caused some confusion. So the first of those is annual leave. Now the confusion about this was not helped by the fact that the guidance on this was totally silent. So the guidance on the interaction between furlough leave and annual leave, there was nothing mentioned about until the 17th of April. However, now we've had a little bit of clarity, and it's been confirmed that employees continue to accrue annual leave whilst on furlough, and that they are entitled to take leave during this time. There was a little bit of debate about whether if they took annual leave during the 3-week period of furlough, that broke up the 3-week period. But no, we've had confirmation that that's fine. They can take annual leave during this furlough period. In terms of what should be paid, well, we know now that this is going to be usual holiday pay, so in accordance with the working time regulations. So where furlough pays 80% of normal wages, then employers are required to make this up to 100%, so the pre-furlough wages for any period of annual leave taken. So just looking on a practical level, we've got 2 bank holidays coming up in May, and thinking about what you should be doing in respect of annual leave and bank holidays regarding any staff that you may have put on furlough. So if you have any staff on furlough leave and they usually work bank holidays, then as an employer, you can agree that this is included in the Coronavirus Job Retention Scheme grant payment. If your employee usually has the bank holiday off, then you must top up their pay to their usual holiday pay levels above the 80% furlough, or give them a day off in lieu. There may be some employers that don't want to or can't afford to top up the furlough pay, and then on that basis they want to cancel people taking their statutory annual leave. I mean, this is something that can be included within a furlough agreement to prevent them from having to pay extra above the government grant. But if you've not done this and you want to cancel annual leave, it's important that you remember there's an obligation to give the requisite notice under the working time regulations. So we've had a little bit of clarity in the area of annual leave. Another question actually that we've had, I've had a couple of times, is about unfair dismissal, about whether if an employer makes someone redundant instead of placing them on furlough, whether that would be unfair dismissal. And as you can imagine, that's a difficult question to answer, but I think it's something that's relevant and something that employers should be alert to, because a worker who's made redundant rather than being furloughed and has the requisite qualifying service could bring an unfair dismissal claim on the basis that employers fail to consider furlough as an alternative to dismissal. So it's important that employers consider alternatives prior to dismissing, otherwise a dismissal could be rendered unfair. Obviously, it's going to depend, as it always does, on the situation and the facts, and things like the size and the resources of an employer, whether the decision to make someone redundant rather than furlough them was taken before or after the scheme has commenced, what's the financial position of the employer, and also, you know, that would be a relevant circumstance. But I think, in my view, certainly, an employer is going to need to demonstrate that it has genuinely applied its mind to the consideration of alternatives to dismissal, so, and that will include furlough. So that's an issue that's arisen. Just one final point, the guidance from that we've had from the HMRC and the Treasury makes it clear that equality and discrimination laws continue to apply, employment law continues to apply. So don't be fooled at this time, because we're having so this is a period of national crisis. Don't think that all normal laws have been suspended and you don't need to follow procedure. That is absolutely not the case. Employment law is going to apply to anything that you do. So if you're making redundancies, it's important that you still follow processes in the usual way. On a practical level, it might not be the same. You may have to adapt your processes to reflect the unique circumstances, but employment laws does still apply. So as you can see, just from the couple of issues I've mentioned, the scheme can be quite complex and does require consideration, and this may be something that we can help you with. So if you have any particular issues about this, then please contact us.
Hayley, thank you very much. As I say, it's always struck me that employment law is particularly technical, and I suppose it's so difficult given everything is so new and so fresh that employers need to be acting correctly right from the get-go. I've got a question here from Mark Rogoff. Hayley, are employers required to offer to roll forward holidays to the next holiday year?
Well, there has been an amendment to the regulations so that employees who have not been able to take their holiday during the coronavirus pandemic are now able to roll this forward into other years. I think there's an unanswered question about whether or not they have been able to take them, whether they've been furloughed, are they able to take them if they're on furlough. The purpose of annual leave under the working time direction is to allow employees to have rest and respite. So the debate is, well, in that circumstance, could they not take them when they've been furloughed? Maybe they're caring for somebody who's shielding, and so there may be an argument about whether or not that is true rest. And so I think if they can reasonably take their holiday before this year, then that's obviously going to be beneficial. Employers are going to not want people to rack up loads of annual leave. If you want to compel your employee to take annual leave, you need to be mindful of the fact that you're going to have to give them particular notice and the correct notice under the working time regulations if you're going to make them give annual leave, which I think is twice the amount of notice as the length of the period you want them to take off.
Thank you for that. Thank you, Hayley. I'm going to take one further question for you. I think we always knew that your area would be particularly
I feel popular.
Indeed. Can the employer buy the holiday and claim the 80% if it falls below the 2,500, and then top up the 20%?
I have to say I don't know the answer to that question. That's not something that I've come across. I'm not sure that maybe would satisfy the purpose of the exceptional purpose of the scheme is to help businesses through the coronavirus pandemic. So it's not something that I've heard of that's possible, but I can certainly have a look into it.
Okay, and in fact, I'm going to take one further question at this point in time, and then we'll move on. is someone is saying that they've furloughed about half of their staff. The others are working flat out and all remotely. And so they've given each of the non-furloughed members of staff 2 extra days of annual leave per month that they're working while others are furloughed. So they're treating the furloughed and the unfurloughed differently. Is there any issue that those working are getting more leave than the others?
I think maybe you have to go back and look at your policies, because it's important that, you know, all employees are treated equally and not discriminated against. I mean, that, you know, that's a strong word to use. But if you are treating some employees different to other employees, I think you have to be careful to look at the reasons why you've made those decisions. I understand, obviously, feel people are working extremely hard. You want to reward them in some way, but it's important to be careful about treating everybody and applying policies equally.
Thanks, Hayley. I think at this point, we're not going to ignore, there's questions, quite a lot of questions coming in for Hayley. I think what we'll do at this point is not ignore those, but park those, because one of our other panelists we've got in another area, which is obviously so relevant, is Robert Rosenberg, who specialises in particular in commercial landlord and tenant. And obviously this is at the top of everybody's issues. So without further ado, over to Robert.
Thank you. Thank you, Ian. I don't think I get as many questions as Hayley, because she's, yeah, I think employment is maybe higher up, but, you know, people like property as well. Okay, so landlord and tenant. Now, normally, well, in the last 6 weeks, I've fielded calls from landlords and tenants. But at the moment, I don't know whether I'm talking to a landlord or a tenant. So I'm going to have to make sure my advice is a bit, you know, I don't want to say one thing or the other. But let's start with, obviously, a lot of people are not paying rent. A lot of tenants aren't paying rent. Now, in normal circumstances, landlords have a specific property right to forfeit the lease and re-enter the property. Colloquially, it's called changing the locks. So the idea is you don't pay rent on the Wednesday, and then on the next Monday, you change the locks, and a load of customers come to your shop and find that big sticker on with, you know, bailiffs, etc. And that never looks good. And you find that most tenants pay up pretty quickly after you get something like that. Now, the government, it was one of the first things they did in their Coronavirus Bill Act. They stopped that happening until the end of June. Okay, so landlords cannot do that. And that was the major tool in their armory for collecting rent. Now, people may have read the papers. There were some aggressive landlords. I don't want to call you too aggressive if that's what you were doing, but there were some landlords who were deciding, you know what, the government stopped that avenue. There is another avenue to go down. And that was insolvency, winding up the tenant company. Now, my colleague Stephen's already talked about that and has already told you that as of last week, the government started saying that that avenue is going to be closed down as well. Not sure it's entirely been closed down just yet, but that's the idea. Okay, so they're the two ways of getting rent. And at the moment, both appear to be closed or closing. Now, what should you all do? What should landlords do? What should tenants do? And this advice goes to both of you. You pick up the phone and you talk to each other, because ultimately you're in partnership. If a tenant can't pay his rent, the landlord will at some point stop getting rent. And that's no good for the landlord, and it's no good for the tenant. So you need to talk. Another thing you need to do is look at your lease. This week, I got a call from a client who said, this was a tenant. Said, I don't know what to do, don't know whether we should pay rent or not, don't know what position we're in. I said, well, how long's your term? She said, well, we've got another 5 years left. I said, just send me the lease. So the tenant sent me the lease, and turned out that they've got a break clause in November. I said, that's fantastic. You've got amazing leverage over the landlord here. You just phone them up and say, let's talk about things going forward. Oh, and by the way, if we don't reach anything that's a good agreement for me, that's it. We can part ways, and here's my notice. So it's important to look at your documents, because you may have forgotten that break clause, whether it's for the tenant or the landlord, that you just, you did it 4 or 5 years ago and you've probably forgotten. I mean, I'm assuming that people don't read leases for bedtime reading. Even I don't, okay? Okay, so you're gonna talk, because you're in partnership. Come up with a deal. Now, what sort of deals are being done right now? I'll tell you. Some tenants are being given rent-free, and you could do that, let's say, 2 months of rent-free, or you could do 4 months of half rent. Same thing, but feels a bit better. Most tenants appear to be getting monthly rents now. Obviously, if you're a tenant, you want to try and keep that going as long as possible. And another really innovative way of trying to get some agreement that's very much in line with this idea of partnership that I'm talking about is that a tenant says to the landlord, let me off paying rent for 6 months, or let's call it 6 months. And in return for that, I will take another 6 months at the end of my lease, right? So it's meant to finish in June 2022. You say, give me 6 months rent free now, and I'll pay it back in, between June 2022 and December 2022. So you'll get a little bit more certainty, and you'll get a bit more of the lease that you never really expected. Okay, so there's some ideas about what you can do to sort of work things out, and I hope that gives you a flavour of what's going on in the market. And yeah, Ian.
Thank you, Robert. As usual, Robert's renowned, as well as obviously being excellent at what he does. He cuts straight to the chase. I liked your tips there. One thing that strikes me, obviously, really commercial ideas. Of those ideas, are these things that either landlords or tenants, can they do it, just get on with it as between them? Or any of your ideas, are these things that really they do need lawyers?
That's a very good question, Ian. Thank you. Let's stay with monthly rents for the moment. I think there you can send an email backwards and forwards. If you need to print it, and that should encapsulate and agree a monthly rent provision. But for something more detailed, like for instance what I was talking about with a rent free of 6 months and then adding on 6 months at the end of the term, that's going to need lawyers, because you might need to pay stamp duty, and you also, if you're a landlord, you want to make sure that if you're going to give something here to the tenant, you want to make sure that when it gets to June 2022, that the tenant just says, oh no, forget about those final 6 months. You want to make sure that the tenant at that point is still locked in, because remember, at that point, assuming we don't get another coronavirus, the tenant will have more money then, and that's when you want to be able to enforce things. So yeah, most of the time in those sorts of deals, you definitely will need to get a lawyer to help you out. But for things like monthly rents, make sure you get those in writing or in an email. Okay. All right, Ian?
Excellent. Thank you. As I say, these are just such difficult times, and I mean, I think we'll develop this afterwards, Robert. There's also, I've seen a lot of discussion going on as to whether the circumstances surrounding the landlord and tenant relationship give rise to any grounds by which the tenant doesn't need to pay rent. And I think, but we'll develop that. I think during the Q&A. The next and final topic to discuss is going to be given by myself, and is really relating to the impact of the current situation to general and commercial contracts. It goes without saying, we all enter into contracts all day and every day. Informal agreements, electronic agreements when we're acting online over the internet, and obviously more sophisticated commercial contracts that parties enter into, often negotiated by lawyers or between parties on standard terms. Often what's not on a day-to-day basis considered until you get a situation like now is what happens when the supply of goods and services can't be provided either at all, or certainly within the time frame everybody envisaged or contracted, and what happens then. In English law, there are two specific concepts that come into play. These are known as force majeure and frustration. And they're two entirely different concepts, and I'll go through each of them in a very general way, because you can read tomes on these two legal concepts, but the idea is to at this point in time is to raise it as a discussion and just see where it takes us. Now, force majeure is effectively an express agreement provided for within a contract. So you're only going to find it in a properly drafted written contract, and you will look often in the small print to what's known as a force majeure clause. This will set out circumstances when one party or the other is entitled to say an event has arisen, which means that the performance or the failure or inability to perform will not give rise to a contract claim for damages. So the starting point is to look at how the force majeure clause is defined. Often you'll look at them and you'll find them in insurance contracts, by way of example, and in those contracts they'll be very specific, particularly even with pandemics, and they'll name the pandemics. Now, being really on point here, if the force majeure clause is saying that certain pandemics and diseases give rise to a force majeure, then you're not going to be able to rely upon it in the current circumstances, because quite obviously it won't have been named. So that's the starting point, to analyze whether or not you can fit the current circumstances into the force majeure clause. Then you'll have to look at, even if this event does fall within the force majeure clause, to what extent can you rely upon it? In other words, is the contract saying that you need to have a complete inability to perform to rely upon it, or is it going to be simply a partial inability? Again, it's always the devil is in the detail. Even if you do have and can rely upon the event, then you need to be careful, because akin to, as Robert was just discussing with landlord and tenant, there'll be notices that you have to serve on the other party, and if you don't serve them correctly, you won't be able to rely upon it. What the force majeure clause will do is it will set out what the parties will do in such an event. So in fact, the real effect of the force majeure clause is to suspend the performance of the contract normally, so that if a party in this situation can't supply goods, it will deal with how that's going to be addressed. The force majeure clause will often deal with how costs are dealt with. So if one side has incurred costs, which is often the case, it will deal with it. If it's silent on that point, the common law steps in, and the normal rule is the costs follow the event, so that the party that's incurred the costs will have to bear the costs. So really, if you do have a commercial contract, you need to look at it very carefully, see if you do have a force majeure clause, does it work in the current circumstance, and if you can, act upon it with adopting the correct procedure. Now, the other concept is known as frustration, and frustration is purely a common law remedy, and this comes about whereby one party will argue that because of the coronavirus, it is simply unable to perform the contract. Now, again, as you would expect, the court is going to examine very carefully whether that is really the case, or if in fact the circumstances have altered, but some sort of performance is possible. I'll give two classic examples. If, unfortunately, which I'm sure is the case, you've booked a wedding hall for an event for next week, that's just not going to be able to take place. It's against the law, and quite clearly it's not going to happen. So again, if at that point in time the wedding hall provider is saying, well, there you go, we'll give you a credit note, you're entitled to say, no, hold on, we think the contract is completely frustrated, it's incapable of being performed, and therefore we want our money back. The flip side is, on a general basis, the landlord and tenant relationship. Even though we're experiencing the lockdown, I think there's a lot of discussion on this, but it's going to be, certainly on a general basis, difficult to argue that a lease has been frustrated, because the effect of frustration on a legal basis is to bring the contract to a complete end. So I just really cannot see any court accepting that because of the current circumstance, a lease will be brought to an end. The final thing I'll say on both of these areas is, whilst they may be very relevant, and you may want to or need to use them as legal concepts, you should do so carefully, because if you get it wrong and you assert that you can rely upon a force majeure clause, or you assert that the contract has been frustrated, and in fact you're wrong, you can find yourself on the wrong end of a breach of contract claim for unlawfully terminating the contract in the first place. So be careful, but similarly, if you've got contracts and you think you're in trouble, look carefully now. Now, that's the end of what I've got to say on commercial contracts. We're getting a lot of questions in from various people. And so while I'm sure you've heard enough of me for the last few minutes, I'm going to, I see we've got quite a lot of questions from our attendees, in particular on employment law, and I'm just scanning through here, and I believe there's a question. 1 second, just coming right here. Hold on.
I can take one of them at the moment, Ian. Just
okay, go on.
Somebody's asked, with tenants, building is open. and the landlord says they'll give a refund, but the tenant is up to date on their rent. I mean, yeah, I think in your position, I would definitely give them a call and certainly try to get monthly rents from them, and say, whereas many tenants of yours, they mentioned it's a big landlord, whereas many tenants of yours are simply just not paid rent. We've been good. Please, can you reflect back some of that goodwill and give us maybe a month or two rent free from the June quarter, and see how that goes. But so in that regard, you're going to have to use the goodwill. Somebody else has also asked whether they can, whether the current situation gives tenants rights or leeway to return the lease if they can't agree on rent. Unfortunately, that, whilst the government has helped out on initially with stopping landlords from forfeiting and changing the locks, and stopping landlords from winding a company up, they have not said that you can simply give back the lease. I think they want the economy to be able to carry on, and and hopefully we'll be back in our buildings in the next 4 weeks so that we're able to go. And I see that somebody's also asked about we've mentioned insurance and whether we're up to date with the Hiscox stance. Obviously, we're not insurance experts, but many professionals are aware with Hiscox stance, and I've always advised tenants of ours that they should get business interruption insurance, and obviously that is a hot potato at the moment, that the likes of Hiscox, who are normally known as a very, very good insurer, have come out and so far said they don't wish to insure for COVID-19. I'm not really surprised by that stance. I think, really in reality, the government is insuring the economy and this at the moment. So personally, it didn't surprise me. And we found from the property angle that there's little at the moment that we know of that people are able to get from insurance. But I would now like to hand back to Ian. Hopefully you can go.
Thank you. Thanks for that, Robert. Stephen, one of our attendees wants to know, there are architects, and what they are saying is that often people pay all the way along, but then when it gets to the final tranche, they withhold. And obviously they want to try and avoid litigation, and even both you and I are litigators, and we would support that position. Have you got any advice there?
Yes, I think the position is that there is certainly going to be situations where people are going to try to take advantage of this coronavirus situation that we're in now. And so, as in this particular case, where or perhaps if you've had a building project or something and you've been doing the works regularly and there's been no complaint, and then all of a sudden you put in that last invoice and they start saying, oh, we're not happy with the work, we're not going to pay for it. Actually, this is quite a common problem that we encounter even when there isn't the coronavirus. But it's all going to be down to documentation, really, and the courts are going to be wise to this. Because if the building works or have been taking place, say, over 6 to 9 months, and there's been no complaints, no written complaints, nothing on site being said, then all of a sudden someone tries to find an excuse for not paying the last invoice, then obviously, what are they going to rely on as to what's actually wrong? They won't have any documentation to show that they've raised anything in the past. And what we actually do to try to avoid litigation is we will write a very detailed letter of action, a letter of claim before action, and we'll ask for a prompt response, setting out the various reasons why the person says that they shouldn't pay. And then we'll go through that. We'll take instructions and we can then respond to that, and we can put pressure on them to retract those allegations and to pay up. Or perhaps there may be a few things which are correct, and then we can come to some negotiation. But we will not let people use the coronavirus as an excuse for not paying.
Thanks for that, Stephen. Hayley, over to you at this point. Someone's asking if an employer is only making some employees on furlough, is there a concept of being unfairly chosen for furlough and that giving rise to a claim?
Yeah, so I think that that's a good question, and it goes a little bit back to what I was saying before about, you know, discrimination laws still applying. When you're deciding who are you going to choose to put on furlough, I suppose you could ask the volunteers. I mean, you may have already done this, but you could ask the volunteers, but then you could end up with more people than you need. But if you've got a group of people that are all doing the same job and you only need half of them, then you're going to have to apply a fair and objective selection criteria to make the decisions, to decide who stays and who's furloughed. I think probably the longer that you have to make that decision, so the less the urgent the financial need is, then the greater the expectation there's probably a more comprehensive procedure being put in place. But if, you know, you're in financial dire straits and the decisions need to be made quickly, perhaps there'll be less of an expectation that you know, a more stringent procedures applied. One option is drawing up a matrix of objective criteria, such as in redundancy. But the most important thing is your decisions must not be discriminatory, except perhaps in cases where it can be justified. So it would be direct discrimination to use age, for example, as a criteria to put people on furlough. But if you put everybody who was over the age of 70 on furlough, that could be justified. Because you would have a defence for that. It would be justified because it would be a proportionate means of achieving a legitimate aim, and the legitimate aim is protecting the health of this particular group that's been identified by public health as being at risk. So in that case, that would be a fair way that wouldn't be discriminatory. But yeah, use a fair and objective selection criteria to avoid putting yourself at risk to making decisions which could be discriminatory.
Unmute.
Thank you. Sorry, there was I was muted, which my wife only dreams about. So I won't tell her that it's been achievable. I see one question coming up. I don't know if myself or maybe over to Stephen. Somebody's saying they've got business interruption insurance, but it doesn't seem to cover the current situation under a notifiable disease nor compulsory closure. Are we aware of any cases where insurers have been challenged? Stephen, I'm not sure if you're aware. I'm certainly aware. I've been speaking to someone who believes that their business interruption insurance may cover this event. And as you'd expect, business interruption insurances are on standard form basis from the particular insurer. So I think what I was saying to that client is they should liaise very carefully with their broker, because it seemed to me there must be a class of businesses with that same wording and group together and challenge it quite strongly. So, but I'm not aware of any actual cases. The other thing that I think is an interesting area, and I'll pass this over to an extent, or perhaps we'll have a conversation, Robert, is that I know whilst normally a landlord and tenant relationship is going to struggle for the tenant to argue it shouldn't be paying rent. But I wonder what the situation is going to be, not with just businesses like ourselves, lawyers, but say if you have a lease with a specific user clause in it, and I'll use an example, say like a dentist. So the user clause in the lease is to be for the premises to be used exclusively as a dentist practice. And my understanding at the moment is that the current regulations say that dentists simply must not practice. I'm not asking you to provide a definitive ruling. Do you think there could be any argument there on some rent suspension?
look, we in the last few weeks we've gone through the standard leases, and we've looked at whether tenants can get out of paying rent on the basis that their property has been damaged by insured risks. So, for instance, in every single lease, if your building is set on fire and you can't use it, the rent suspends, and that's because fire has been insured against, and therefore that clause kicks in. Unfortunately, we can't find a way, and all the lawyers I've spoken to can't find a way of getting rent suspension on the basis that you can't use the property due to damage, because no damage has actually happened. It's just now. In fact, what's been going on recently into new leases, there's lots of debates about the coronavirus clause, which would say something along the lines of, if there's another epidemic, or if this carries on, then rent suspends along the same lines as insured risks. Interestingly, after 9/11, landlords and tenants came up with the concept of uninsured risks. And this idea of uninsured risks was that maybe in the future you wouldn't be able to get terrorism insurance. And if you couldn't get terrorism insurance, in order to suspend the rent and cover the lost period, then who would bear the risk? And really, in the end, landlords and tenants, very interestingly, effectively started to share the risk, whilst it's never really happened because terrorism insurance has always been affordable. What the documents say is that landlords and tenants share the risk. Now, I've been like a politician and not really answered your question, but in answer to your actual question, you're talking about a permitted use in the lease, and the permitted use is normally a covenant against the tenant to not use it for anything else. So I don't think under that specific clause, dentists would be able to claim, well, we can't use our premises, therefore the rent should suspend, but they should examine their rent suspension clause and see if by some miracle there is something in there that that could get them out. But at the moment, it doesn't seem like people can do that.
Thanks for that, Robert. Well, I think at this point, I can see we're quite amazingly running spot on to an hour, and I can't think of anybody wanting to listen to lawyers for more than that. So I'd like to thank everybody for joining us on, it goes without saying, really difficult times. I hope that this has been useful, as I say, to actually be able to get our ideas across various sectors. I think the takeaway that I get from listening to my other colleagues, forget listening to myself, is that whilst we can advise on the law, and that is what we analyse, what we're also seeking to do, and I think that's our primary focus, is to give you sound commercial advice with a capital C, because anyone should really be able to advise on the law, but it's the commercial angle that people are looking for. We're going to, because we can't see things altering dramatically in the next few weeks, so we're going to be doing more of these panel discussions and general webinars. So please do keep an eye out for these. We'll contact people. Look out for us on the various social media, Instagram, Twitter, etc., that all my colleagues so love. Thank you for today. If some of your questions haven't been answered, we'll try and get back to you, but feel free to go online to our website and contact myself and my colleagues directly. And above all, stay healthy and stay well and stay safe. Thank you.